controversy around Betsy DeVos's recent announcement to take on the battle of university sexual misconduct, I think it's time we talk Title IX. Title IX is one of those terms that is thrown around, but I don't think the average person really knows exactly what it means and what it entails. It's promoted as the only thing standing between sexual assault victims and a lifetime of re-victimization, or the only possible way to investigate and punish cases of sexual misconduct on college campuses. But really, all it means is that the university becomes responsible for what should probably be a criminal investigation into a violent crime, uses questionable and non-standardized tactics, and the worst thing that usually happens to the perpetrator is getting expelled. Doesn't really sound like justice to me. Betsy DeVos spoke about several times when Title IX failed victims and the falsely accused. And unfortunately, this is not just a rare handful of isolated incidents. Feminist blogs are filled with tales of horror in which women's rapists were allowed to go free. It seems like there's always a case of mistreatment in the news, and we all remember what happened with that Rolling Stone piece. Like most government regulations, the stated goal is something moral and just that appeals to the emotions and a desire to make the world a better place, but in practice falls short and leaves behind a whole host of unintended consequences. To see how and why, we first need a brief history lesson. Title IX actually goes all the way back to 1972 and was an amendment to the Higher Education Act of 1965. Title IX reads, "No person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance." The law did wonders for equality and opened doors for women in the world of higher education and college sports. But that law, as it stands, doesn't say anything about sexual assault and how it's dealt with on college campuses. So the question becomes, how did Title IX morph from an anti-discrimination law to a set of rules on how colleges need to investigate and adjudicate sexual assault cases? These changes began in the 1980s with the movement to reconceptualize rape. Until then, rape was largely seen as something committed only by creepy, violent strangers and ignored the prevalence of assaults being committed by someone the victim knows. Advocacy groups began to argue that such crimes were a secret epidemic on college campuses and that the justice system largely ignored or failed these cases. Then in 1986, in an unrelated employment case involving the University of Chicago, the Supreme Court decided that sexual harassment falls under sex discrimination and thus was covered by Title IX. Also in 1986, a young woman named Jean Clery was raped and murdered on a university campus. While Jean's murder was committed by a stranger, the Clerys and other advocates argued that acquaintance rape was an epidemic, especially on college campuses, and pushed back against the attitude that students should have sexual autonomy. Instead, the movement pushed for universities to not only recognize the problem, but to take preventative measures and find ways to regulate their students' sex lives. Jean's parents then founded the Security on Campus organization and led the legislative push to enact the Clery Act, which was made law in 1990. Clery's parents also argued that the university had failed to provide adequate security and safety information on campus, so the Clery Act required all colleges and universities that receive federal aid to report annual crime statistics, disclose preventative and security measures, and develop and disclose procedures to be followed in the investigation and prosecution of sex crimes. Later amendments also required that the school offer victims counseling services and provide various living and academic accommodations. A series of Clery Act violations were made public throughout the 1990s and brought media attention to the situation, creating the widespread perception that colleges and the justice system just didn't care about sexual violence. One solution to this problem was lawsuits against the schools themselves for failing to protect their students. One of these lawsuits included a 1998 case in which the Supreme Court decided that schools can only be held liable for private damages if they knew of and purposely ignored cases of discrimination, aka only if the schools engaged in deliberate indifference. The definition of sexual harassment also morphed to include all sexual violence, as sexual violence was considered to be an impediment to a productive learning environment and thus robbed students of equal opportunities. This led the way for another case that decided that schools could be held liable for ignoring cases of sexual harassment. And while there's no one landmark case that transitioned rape from a criminal issue to a university issue, in a 2003 case involving Yale University, a federal court ruled that rape constituted a case of severe sexual harassment and thus fell under Title IX. As a result, colleges passed stricter and stricter sexual misconduct policies, in part to address the problem and in part, no doubt, to avoid costly lawsuits. Because once a school has been accused of deliberate indifference, it's pretty hard to prove otherwise. Still, advocates said that this was not enough and now looked directly to government to create new compliance guidelines. Time went on, and critics said the new guidelines were still not enough to stop sexual violence, and after a series of Dear Colleague letters from various members of the Obama administration, the Violence Against Women Act was reauthorized and made many of those Dear Colleague suggestions into law, as well as took policy making away from the Department of Education's Office of Civil Rights and instead gave it to the Clery Compliance Division. The Obama administration then made Title IX a priority, and the government rolled out nearly 1,000 pages of new federal regulations devoted to sexual violence on college campuses. 1,000 pages! Unfortunately, while the government has implemented guidelines on what has to be done, it never issued any concrete rules on how universities meet those guidelines. About the only thing set in stone by the regulations was that universities could hold a lower standard of evidence than criminal cases, and that if they failed to uphold Title IX, they'd lose federal funding. The guidance also discourages universities from cross-examining students in order to prevent them from experiencing further trauma, even though cross-examination is one of the cornerstones of due process. All of this has resulted in a horrible mess that even feminist website Jezebel has sometimes called into question. And that's saying a lot. That is why Betsy DeVos spoke about scrapping the current rules and coming up with a better, more standardized replacement. She spoke on how Title IX itself does not explicitly speak to violent crime and argued that violent crime should fall under the Justice Department, not individual universities. From her remarks, it doesn't seem that she's trying to silence rape victims or invalidate their experiences. After all, Title IX missteps are not uncommon news items. So in light of that, here are the cases that DeVos referenced in her speech, plus a few more. First, we have the case of Sarah Tubbs, a 22-year-old student out of Stony Brook University in New York. She alleged that she was assaulted in January of 2014 after a night of drinking at a campus party. She accompanied her alleged attacker to his dorm room with the intention of having sex, but changed her mind once they arrived. She reported that she then blacked out and therefore couldn't fight him off when he forced sex on her. Unfortunately, due to the school's Title IX investigation policies, she was told 1 week before the hearing that she would have to prosecute her alleged attacker herself, despite the fact that she has no legal training. No police, security, or mental health professionals were allowed at the hearing. Her alleged attacker was found to be not responsible, despite campus rules requiring explicit consent during sexual encounters and rules that said consent could not be given when drunk. Tubbs filed an appeal but didn't hear back from the university. She then sued them for forcing to prosecute her own case. We also have a recent case out of the University of Southern California. According to recent graduate Zoe Katz, her boyfriend was kicked out of school when a nosy neighbor saw them roughhousing in her front yard. The neighbor told his roommate, who then told a coach in the college's athletic department, who then reported it as a sexual assault to the school's Title IX office. Katz attended a mandatory meeting where she refuted the assault story and explained what had happened. In turn, school officials became convinced that she was only protecting her boyfriend out of fear and told her that she was a, quote, battered woman. They ruled against her testimony and her boyfriend's, and not only barred him from campus, but barred him from playing football, contacting any of his teammates, and contacting Katz. Katz and her boyfriend have both hired lawyers, and just this week, the court rejected his petition to be allowed back on campus on the basis that it would question the school's decision. At George Mason University, a student saw her rapist ultimately go free because they denied him due process. The two were involved involved in a BDSM relationship, and during one of their encounters, she pushed him away, but he allegedly continued because she didn't use the agreed-upon safe word. The male, who documents call John Doe, was tried before a 3-person panel at the school. Both parties were interviewed at the 10-hour hearing, which eventually found John Doe innocent because of the safe word issue. The woman then filed an appeal, and the dean of students assigned himself to the case, despite the fact that he admitted he had, quote, already prejudged the appeal and decided Doe was guilty based on previous conduct issues at the school. At the second hearing, Doe wasn't given the opportunity to defend himself, so after he was expelled, he hired a lawyer and successfully sued the school for denying him due process. This was despite the fact that he later admitted that the woman had used the safe word and he had ignored it. In yet another case, out at Colorado State University Pueblo, Grant Neal was expelled when his relationship with one of the trainers, also a student, was discovered. He'd left a hickey on her neck, another trainer saw it, assumed the sex had been non-consensual, and reported him to the school administrator's and Title IX office. Neal was not made aware of the charges, was presumed guilty, and suspended before the hearing even took place. The school refused to interview any of the witnesses he provided and then told Neal he couldn't re-enroll until after the student trainer graduated. At Amherst College, a male student was expelled for allegedly assaulting a female student while he was blacked out. The young woman, Anna Seward, was fully lucid and performed oral sex on him despite the fact that he was her roommate's boyfriend, and immediately after the incident not only told her friends via text message that she had initiated contact, but also minutes later invited someone else into the room and had sex with them too. Nearly 2 years later, after her friends had found out and ended the friendship, she filed a Title IX complaint. The male student, another John Doe, had no recollection of the encounter at all, and at the hearing, Anna herself reported that the only pressure she felt was from other students telling her to get a room. Only one administrative official was responsible for the entire investigation. Despite the fact that she found Doe's story to be credible and admitted it wasn't clear to her how Anna's story was one of non-consensual sex, Doe was found guilty and expelled. Another case that DeVos referenced didn't even involve rape or assault. Keaton Walbon was a student at the University of Tennessee and was punished for sexual harassment because of an incorrect quiz answer. Walbon's offense occurred in his geology class, taught by a Professor Bill Dean. Dean gave the class a quiz that included the question, quote, "What is your lab instructor's name? If you don't remember, make something good up." Walbon reports that he couldn't remember, so he made something up and put down the first generic girl's name he could think of, which was Sarah Jackson. He was given a 0 on the quiz with the comment inappropriate from the TA because apparently Sarah Jackson is a porn star. I don't know, Wiki only turned up an Olympic swimmer, an artist, and a teacher. And Google gave me one of the models from Deal or No Deal. I did get some pictures of a chick in lingerie, but it was like mom bras. Apparently not having the same porn knowledge as his professor and TA, Keaton was notably confused and emailed his professor to ask about his grade. He wrote that he had had no idea about the porn star and that he was in no way trying to be cute or clever. The professor refused to meet with him and accused him of sexual harassment for objectifying the TA and making her uncomfortable. But the case gets better. Apparently, Dean didn't actually report the infraction. Instead, an unidentified faculty member reported it when they saw the story on a college news website called Total Frat Move. They felt the website was mocking the harassment accusation and reported it to the school's Title IX authority, who, of course, opened an investigation. The results of that investigation were not made public. And while that case might seem far-reaching, it's certainly not the only one. A student at Columbia was charged with gender misconduct for calling himself handsome in a Chinese class. The professor found the remark funny, but a student complained to the administration. Last year, RAs at UMass Amherst accused students of Title IX violation for writing "Dicks Out for Harambe" on dorm whiteboards, claiming it was a sexually inappropriate microaggression. And as part of Title IX enforcement, City University of New New York's Graduate Center banned the use of the title Mr. and Ms. in 2015. Stories like this pop up again and again and again. Various college news websites are littered with them, and these stories aren't just found on conservative-leaning small government news websites. You can find them on Slate, HuffPost, The Atlantic. The list is endless, and yet feminist blogs complain that Title IX doesn't do enough to protect victims, but then recoils at any suggestion to take a closer look at the law. Title IX defenders like KnowYourNine.org will argue that sexual assault is actually too serious to leave to the criminal justice system, despite themselves admitting that there is widespread university mistreatment of sexual assault victims and that the worst punishment is only expulsion. Rape is a terrible, vile crime, and colleges have already demonstrated that they are not the appropriate avenue for any of these issues. As always, thanks for watching, and a big shout out to all of my patrons who make these videos possible. If you like my videos, please don't forget to like, share, and subscribe, or follow me at any of my social media links down below. If you want to help support my channel, you can also do so with Patreon, PayPal, or Bitcoin, which are all linked in the description, along with every information source used for this video. Again, thanks for watching, and we will be back to our regularly scheduled Liberty Update next week.